In this immigration law update video, I want to look at applications for indefinite leave to remain under the long residence rule 276B and the problems thrown up by historic gaps in lawful residence. In these immigration update videos, what I'm trying to do is give a quick summary of the latest cases, policy developments, statutory developments. If you need a more in-depth training course, sign up to one of my seminars coming up around the country via organisations like HJT Training, MBL Seminars and the Solicitors Group. So, the long residence rules provide for indefinite leave to remain where somebody has 10 years lawful residence in the United Kingdom. Now, what about where there's historic gaps in that lawful residence? Well, there is provision made in 276B Roman 5, and it says the applicant must not be in breach of the immigration laws except that where paragraph 39E of these rules applies, any current period of overstaying will be disregarded, full stop. That's okay, not controversial. That's about current periods of overstaying. So if you're an overstayer when you make that application, as long as 39E applies, you're okay. But what about historic gaps? 276B Roman 5 goes on to say, any previous period of overstaying between periods of leave will also be disregarded where A, the previous application was made before 24th November 16 and within 28 days of the expiry of leave, or B, the further application was made on or after the 24th of November 16 and paragraph 39E of these rules apply. So obviously there's this, the significance of the 24th November 2016 where the grace period changed from 28 days to 14 days. Now you may think all well and good, but problems have arisen following a case in the Court of Appeal called Ahmed and the Secretary of State for the Home Department, 2019 EWCA Civ 1070. And that's from the 21st of June 2019. And that actually builds upon an earlier upper tribunal case, also called Ahmed, but a different case. And it's R on the application of Ahmed and the Secretary of State for the Home Department, brackets para 276B-10 years lawful residence, close brackets, 2019 UKUT number 10. Now in the Ahmed case, the Court of Appeal found that 276B Roman 5 couldn't be used to cure gaps in the 10 years lawful residence. So at paragraph 17, the court summarises its conclusion, says it's clear as a matter of construction of the immigration rules that an applicant cannot rely on paragraph 276B Roman 5 to argue that any period of overstaying should be disregarded for the purpose of establishing 10 years continuous lawful residence under paragraph 276B Roman 1A, because they find each of the provisions are free-standing. Now, to me, this is a hugely problematic decision and renders that second sentence of Roman 5 just obsolete, because otherwise, what's the point of that paragraph, which is specifically to deal with historic periods of overstaying? Now, the Secretary of State has long residence guidance, and interestingly, the latest version of the long residence guidance is version 16.0 from the 28th of October 2019. So it's after Ahmed, a significant period after Ahmed. But the Secretary of State maintains the position on a plain reading of Roman 5. So it says at paragraph 16 of the guidance, gaps in lawful residence. You may grant the application, so it's a grant under the rules, if an applicant has short gaps in lawful residence through making previous applications out of time by no more than 28 calendar days, where those gaps end before the 24th November 16, has short gaps in lawful residence on or after 24th November 2016, but leave was granted in accordance with paragraph 39E of the immigration rules, and meets all the other requirements for lawful residence. So the current Secretary of State's guidance contradicts what was said in Ahmed. The Secretary of State's guidance also contains a wider discretion to grant outside of the rules where there are other gaps, where there are exceptional circumstances. Now, in Ahmed, it says, of course, the guidance can't be used to interpret the rules. But certainly the Secretary of State's position before the court in Ahmed is contradicted by their own guidance. I think this is hugely problematic and we need clarification. In your long residence applications, I think you certainly should rely on their policy, because the policy is the Secretary of State's extant guidance and says how their caseworkers should decide decisions. If you're faced with an Article 8 appeal where the long residence rules are in play and there are gaps, it would be worth pointing out to the judge the long residence guidance, because that will be material in assessing the public interest, because this is the current policy of the Secretary of State in when they will overlook gaps. So there are issues in this area, and certainly there are contradictions which need resolving, but the policy is helpful and should be relied upon. I hope that helps you in your applications. For further reading for immigration advisors, look at the article in the February 2020 ILPA magazine by Richard McKee. There are also some helpful analysis on the Free Movement blog in relation to this. But hopefully this will help you mind the gap and your applications will be successful.